Many companies send demand letters. Far fewer get paid quickly. Why? Because most letters are generic templates, emotional, vague, and disconnected from enforcement reality. In Vietnam, a demand letter works best when it is built like a legal position, evidence-led, procedure-aware, and ready for escalation if needed. At LTS Law, demand letters are not routine paperwork. They are structured legal instruments designed to trigger engagement, speed up settlement, and strengthen recoverability. In this video, we'll take you behind the scenes of how we draft demand letters for foreign clients doing business in Vietnam. 1. Understanding the contract position. We start with the contract and the transaction facts. What exactly was delivered, accepted, and invoiced? What obligations were breached, payment, acceptance, or performance? Are there specific notice requirements, dispute clauses, or payment milestones? We also confirm who signed, what authority applies, and what documents prove the deal structure. We don't write letters from frustration. We build them from verifiable facts, because facts drive negotiation and withstand escalation. 2. Debtor profiling and risk indicators. Next, we anchor the letter in your contract and applicable Vietnamese law. We map how the claim would likely be argued in arbitration or court, what the other side might deny, what evidence will be challenged, and what the real collection risks are. Then we reverse engineer the demand letter to reflect a position that is consistent with that legal reality. This is what transforms a letter from a request into a credible preview of a claim, with a clear narrative and a clean supporting record. 4. Bilingual precision and counsel sign-off. For foreign clients, language is a common weakness. Where appropriate, we draft the letter in Vietnamese and English with consistent meaning, so nothing material is lost in translation. The letter is signed by licensed Vietnamese counsel, and where relevant includes firm identification details. This supports authenticity, and strengthens proof of notice if the matter escalates. The goal is not formality for its own sake, the goal is clarity that survives real procedures. 5. Structure that business leaders respond to. A strong demand letter must be readable for decision makers. Our structure typically includes an executive breach summary, the contractual basis, a document-backed breakdown of amounts due, a clear deadline, often in a 5 to 10 working day range depending on the case, and the next steps if payment is not made. We attach or reference an annex list of evidence, invoices, acceptance records, debt confirmations, payment logs, and key communications. Where legally justified, the letter may reference that the creditor is prepared to pursue formal proceedings, and if conditions are met, consider applying for interim urgent measures, subject to legal requirements. The tone stays professional. No insults, no exaggeration, no drama. 6. Delivery that can be proven. A demand letter is only as strong as your ability to prove delivery. We choose verifiable channels based on the debtor and the contract, courier with delivery records, official email communication, or other traceable methods. Then we preserve service evidence carefully, so later, the debtor cannot credibly claim ignorance or deny receipt. This step often looks simple, but it can be decisive in negotiation and in any escalation pathway. 7. Success story, anonymized, from letter to settlement. A foreign manufacturer faced months of silence after performance and invoicing. The debtor stalled and avoided direct responses. After LTS Law issued a structured, bilingual demand letter, evidence-led, with a clear deadline and a defined escalation roadmap, negotiations restarted quickly. We received a settlement proposal within days, and payment followed shortly after according to an agreed plan. Details have been adjusted to protect client confidentiality. The result did not come from threats. It came from clarity, credibility, and timing. Foreign companies choose LTS Law because we combine legal drafting with recovery strategy. We understand how documents, language, and procedure interact in Vietnam. We control tone and structure to keep options open, settlement when possible, escalation when necessary. Most importantly, our letters are not isolated documents, they are part of a complete timeline, evidence pack, notice strategy, negotiation plan, and readiness for arbitration or court if the debtor refuses to engage. If your company is facing non-payment, breach of contract, or silence from a Vietnam counterparty, don't send a generic template and hope. Send a letter that protects your rights and moves the case forward. Let LTS Law draft and deliver a demand letter built for Vietnam procedures, backed by evidence, and aligned with real enforcement. Visit lts.com.vn to begin, because in Vietnam, a strong demand letter is not just words. It is your first strategic advantage.